will be speaking about online dispute resolution and the platform which he's a co-founder in, Mr. Vikas. Just to give you an introduction about Mr. Vikas Mahendra. Vikas is a practicing advocate in Karnataka and also is a specialist dispute resolution professional, especially in arbitration. Who's previously worked with Herbert Smith in their Paris, Singapore, and London offices, and presently is a partner in Keystone Partners, and also is the co-founder of the Center for Online Dispute Resolution. Mr. Vikas, it's a pleasure to have you on the show with us. Over to you, so that you can speak about the topic for today, which is on online dispute resolution. Just give us a moment so that everyone can join in. And in the meantime, I can request all the participants to kindly introduce themselves on the chat box. Over to you, Vikas.
Sure. Thanks, Vignesh, for that very kind introduction. Hello, everyone. I see a number of new faces, so welcome to this. I will try and cover in maybe the next hour, maybe leave some time for questions towards the end of the session also. Give you a little bit of an overview of what ODR is, or online dispute resolution is. Where is it that it can be used? Where is it that it's difficult to use? What are the possibilities? What are the options? Just the broad range of it. Like Vignesh said, I'll speak a little bit about my introduction, because that might help you get some steer as to where I'm headed. I was with Herbert Smith Freehills in their arbitration practice in London, then Singapore, and I realized that there's a number of benefits to that arbitration, sort of the way they're conducted, which is different from the way these things are conducted in India. And even the way they were conducted in an international setting was less than perfect. A lot of steps were very archaic, very mundane, things that didn't require someone of incredible experience to be devoting significant amounts of time doing. So the idea was to see what it is that we could do to improve that space. Where can we bring about technological alternatives? Where is it that can bring about some amount of automation, etc.? And that's where Center for Online Dispute Resolution began. Now, Center for Online Dispute Resolution is more than one thing. It's an arbitration institution. It is, in addition to that, also a platform, a technology platform which people can use based on what it is that they want to do from out of that technology. So for instance, if you want to use only the technology offering and don't want to use any of the institutional rules, that's perfectly possible. But if you want, it is also a full institution which helps you appoint arbitrators, which helps you resolve a dispute from start to finish. Now, what is it about ODR that requires this particular webinar? Why is it that it's so special that people need to be talking about it? First thing is, it's not very different from what things have been. So let's understand how novel it is before we go into what it is that it can be. Arbitration, particularly international arbitration, has used technology for as long as we know it. That technology may have been from very rudimentary concepts like email. Just sending out documents by email is use of technology. Using video conferencing is another aspect of technology. Now, ODR, that's why, is actually a spectrum. It's not something that fits a definition. It's anywhere that you use technology to resolve a dispute. But having said that, because there's a whole spectrum of it, we need to understand where it is on the spectrum we want to be and what are the benefits that being on that aspect of the spectrum brings. The way traditionally arbitration has used it, which is, for instance, only using emails as a mode of communication or only using the video conferencing facilities on an ad hoc basis, has limited ability. Now, if you want to realize the full utility of online dispute resolution, we must try and explore a much, much wider spectrum of where it can be used. With the following three principles in mind, let's try and analyze if that can be achieved. Can we make things faster? Can we make things more fair? Can we make things more effective? And those are the three things we need to look at while considering and analyzing whether online dispute resolution is good, bad, ugly, whether you want to use it or otherwise. Let's talk about making things faster. How can we make things faster using technology? The obvious ways we can think about is just the way you can communicate instantaneously over technology. So for instance, if you want to send across documents, that can be done using technology much faster than it would be possible using the physical world. Which is why, if you compare existing court systems to arbitration, or at least some arbitrations where technology is used in these elements, you can see the time advantages. For instance, if there is a party who's, let's say, Vignesh and I were practicing in the Karnataka High Court around the same time, and we in fact went against each other in a few instances also. And he'll tell you that in real life, about 25% of the life cycle of any case is spent just notifying the other parties, dispatching documents to the other parties. So if you're looking at a civil trial in a civil court, which is about 5 or 6 years on an average, you're spending 1.5 years just communicating with the other party and sending the other party documents. Now, that is one very crucial element where technology can play a huge role. How is that? Firstly, is on notification of the parties. When you're notifying the parties, you can use technological means of notification. For instance, you can use email, you can use SMSs, you can use WhatsApp. Now, in addition to that, you can also use your physical means of delivery, but you don't have to use physical means of delivery with the same limitations that are there presently. For instance, using courier with an automated tracking system, which automatically, the minute that thing is dispatched or delivered, stores the record on a system, can make the process of notifying the other person faster, even if in reality it is a physical parcel that is moving from place A to place B. So on notification, because you have technological alternatives to make things faster, that's one way where ODR can benefit. Next, go to the next cycle of the case. You've initiated a dispute, you've notified it to the other party is probably responded. Now, the other party has to make filings. That's another stage where ODR can make a huge difference. And there, the advantages are both the fast element of it and the accessible element of it. Think of a situation where parties are very distantly located. Let's say, for instance, one of them is in a capital city like Delhi. The other one is rural hinterlands of somewhere in Bijapur, Karnataka. Now, if the person who is there in one of the hinterlands has to try and, maybe file something in the Supreme Court, that person will have to first engage a lawyer, maybe somewhere in Bijapur, because that's the first port of call they have. That lawyer will then have to try and find some AOR in Delhi. The advocate on record will then have to try and get all of this information, and all of that will probably go from that hinterland in Bijapur to the lawyer in Bijapur, from there to Delhi to the AR's office, and then from the AR's office to the court. That entire journey is clearly not efficient, and it is certainly not fast. And that is where allowing an online portal to file documents, file pleadings, is a huge value add, where ODR or online dispute resolution can make a difference. So you've notified the other parties come, file the documents on the platform. What next? How do you conduct hearings? Now, conducting hearings also, there are two aspects of it. One is the substantive element of actually conducting the advocacy. And the second is the procedural bits that are inherent in every hearing. Now, as a number of you might know, maybe either as law students or practicing law professionals, that the life cycle of any dispute is not just the final arguments. It is a number of stages from the start. In fact, if you take the Code of Civil Procedure or the Commercial Courts Act, which has now been recently amended, you'll see that in fact, the trial bit or the hearings bit starts, if not for an interim relief application, with what they call the case management conference, which means that parties come with the judge in that particular instance, sit together and figure out how they need to schedule the rest of the dispute. How many witnesses there are, how do you submit documents, what is the timeline for each of them, etc., etc. Now, these procedural hearings can very easily be conducted online. And in fact, if you look at international arbitration, and when I say international arbitration, I'm not talking of your low value disputes. I am talking about billions of dollars. In fact, one of the most recent matters I handled was about $1 billion with the dispute in Guatemala, the arbitrators in one of the parties in the USA, the arbitrators spread across Toronto, London, Sydney, and we were then in Singapore. Now there, if every one of them had to get together in one place simply to figure out what will be the next stage of arbitration, that's a complete waste of time. It's a complete waste of time, complete waste of effort, and a lot of costs expended. which is why in international arbitration, what they do is that hearing, what they call the first procedural conference, is usually done either by way of a telephone conference or by video conference. That again is another element where, because of the very, very simple nature of the hearing, you can use technology to try and fast track the process and minimize costs. And I will, in fact, and I know I'm running through the entire life cycle of the matter, but I will come back to some of these elements to show you how it can be a significant improvement over what it is that I'm proposing even now. So you have the first procedural conference, then you go to the actual hearings. Even within the substantive hearings, if you see arbitrations in India, some arbitrators are notorious for calling arbitration hearings even for submission of pleadings. So for instance, if you have to file a statement of defense or you want to file a witness statement, while some arbitrators are becoming proficient, some of them, because they want to charge the hearing fee for that hearing, are calling parties for a hearing even to just submit that document. Now, that is, of course, not efficient. In a court situation, you will know that that's in fact the routine, mostly, especially in the trial courts. Maybe not in the high court where the submission happens with the registry, but at least in the trial court level, every time there is a submission that needs to be made or a document that needs to be submitted, that has to happen on a physical interface between the parties. That can very easily be avoided, like I've already mentioned. Even beyond submission of documents, if there are hearings that need to be conducted, and their hearings, I will divide them into two types. First is where there is an oral argumentation that needs to be made. Second is where there is a trial or a witness examination, cross-examination that needs to happen. Now, these two, I'm separating it out because they're inherently of very different natures. Let me address the hearing, which is the argumentation. So far as the argumentation hearing is concerned, that can very, very easily be done on an online platform. Now, rather than just me speaking about it, why don't I give you a little bit of a demonstration of a hearing that we recorded not too long ago, where we had a senior advocate from Delhi, we had a lawyer again, we had a leading arbitration practitioner from Bombay, we had another IP practitioner from Delhi, who conducted a hearing on an online platform. And once we run through that video, which is approximately 8 minutes, I will then take you through some of the elements of where it is that, and you'll probably get a sense of the kind of arguments that is possible to make on this. So I'll share my screen for that. And Vignesh, if I may request you to allow me to share my screen.
1 second, please.
While Vignesh does that, so just to give you a brief background of what this case is, this is actually an IP dispute where one of the competitors is said to have stolen some amount of IP which is belonging to a particular client, and they want some very urgent interim relief. Now, in this particular case, that hearing, which is scheduled on an urgent basis, is now being heard at length. So let me share my screen and take you through that video, which Vignesh, I am not able to do that.
1 second, please. 1 second.
So, or maybe we'll come down to that in a bit.